A constitution bench of the Supreme Court today reserved judgment on a batch of petitions challenging the 103rd constitutional amendment, which introduced the 10% reservation for economically weaker sections in education and public employment. The 5-judge bench, comprising Chief Justice of India cjiuulalit, Justices Dinesh Maheshwari, S. Ravinder Bhatt, Bela M. Trivedi and J.B. Pardiwala, held hearings in the matter for 7 days. Today, the petitioners' lawyers made rejoinder to the arguments that had been advanced before by the union government. For those of you who are not aware of the issue, back in January 12, 2019, the union government had brought about a constitutional amendment to Articles 15 and 16 of the Constitution, which deal with the right to equality and reservations. Prior to this, there were provisions for seats and jobs to be reserved for scheduled castes, scheduled tribes and socially and educationally backward classes. Thus, pursuant to this particular amendment, the government introduced a 10% reservation for general category citizens who are economically weaker. The central government has defined economically weaker sections as those with an annual family income of less than 8 lakhs. Subsequently, several petitions were filed in the Supreme Court challenging the constitutional amendment on the ground that it violates the basic structure of the Constitution. We have made a detailed video on the arguments that were advanced during the prior hearings, the link to which has been given in the description box below. Please don't forget to check it out. The rejoinder arguments today were commenced by Senior Advocate Professor Ravi Verma Kumar. While highlighting the plight of various scheduled tribes living in mountains, deep valleys and areas which were far away from modern civilization, he stated that these tribes were not Caucasians and that it was the mainland Indians who were all Caucasians. He relied on the impact test to state that it was these tribes which were being excluded based upon their race and that this destroyed the equality code by discriminating on the basis of race. He further argued today that the union government has not yet apprised the Supreme Court about the nexus between reservation and poverty, or explain as to why benefits instead of reservation could not be granted to such economically weaker sections of the populace. Today before the Supreme Court, while refuting the contentions of the state that the scheduled caste, scheduled tribe and other backward classes is a homogeneous group and that economic criteria has already been used for granting the right to education, Professor Ravi pointed out that the Supreme Court had itself noted that these classes were not homogeneous groups and that Article 21A of the Constitution, that is the right to education, never excluded backward classes from its ambit. Senior Advocate GOPAL SHANKARANARAYANAN today argued before the Supreme Court against the compartmentalization of classes and also submitted that the 50% ceiling limit was sacrosanct and that violating it would be a shocking infringement of the basic structure of the Constitution. In this regard, he also argued that something inflexible could also constitute the basic structure of the Constitution, that is the unamendable part of the Constitution. Furthermore, Senior Advocate P. Wilson argued that the data submitted by the government was not empirical in nature and as such reliance on the Sinho Commission data and the National Sample Survey Organization, that is the NSSO data, would not help the government establish any reservation. Today's hearing also saw arguments being advanced by Senior Advocate MEENAKSHI Arora, who argued that the Supreme Court's landmark judgment in the Hinduswani case must be treated as a voice of the court and that nothing warranted its overruling merely because it concerned an office memorandum. She also contended that it was the impact of the action which had to be taken into consideration by the court. While referring to the philosophical doctrine of the ship of Theseus, she argued that if the arguments of the government that not all incursions in basic structure violate basic feature unless they are shocking is accepted, then the basic structure doctrine would be destroyed chip by chip. The arguments today were also continued by Senior Advocate SANJAY PARIKH, who stated that the essence of backwardness, which was not economic, should come in the forefront while providing reservations, and Dr. Chauhan, who submitted that historical context and discrimination had to be taken into account while providing reservations to citizens. Following this, the bench today reserved the verdict in this case. Additionally, the bench requested Advocate Shadan Farasat and Advocate Kanu Agarwal to assist the court in putting together the written compilations in concise form within the next 2 to 3 days. For more information about today's hearing and the case in totality, you can refer to our detailed report, the link to which has been given in the description box below. Please do check it out. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.